One of the states that has looked most closely, in fact, the only state that's looked closely at race discrimination in the death penalty is North Carolina. And we're joined today with Henderson Hill, a distinguished North Carolina lawyer, to talk about the experience of North Carolina with its Racial Justice Act. Henderson, thank you so much for being with us here today.
Steve, I'm happy to be here. Thank you.
Well, glad to have you. And would you just tell us about the Racial Justice Act in North Carolina, what it provided and how it made a difference in terms of the way courts looked at race discrimination in death penalty cases?
Well, sure. One of the things that we became painfully aware of, and had been for a good long while, was that solid citizens, hardworking members of the community were being excluded from participation in the criminal justice system. And it became really very clear in the capital cases that increasingly capital trials were tried before jurors that were entirely white. And the Supreme Court had, of course, had a mechanism for dealing with racial discrimination, jury selection. The Batson three-step process was that mechanism. And in North Carolina, it just was not very effective. In fact, it was less effective than North Carolina than in many of the southern states in the Death Belt.
And let me just stop you there for a second. When you say the Batson process, you mean where after the prosecution has struck African Americans, the defense objects, the prosecution gives reasons, and then the judge decides whether there's race discrimination based on the number of blacks struck and the reasons given by the prosecutor.
That's correct. And it's in that second step of the process where the reasons are offered that was so frustrating to litigators and observers of the system, because in that second step, the explanations, the race-neutral explanations, were so clearly pretextual, having to do with the directness of eye contact, body language, where they went to school, whether or not they had children, the age of the defendant, whether they were the age of the defendant, whether they had family members who were involved in the court system. All of these questions, which first of all had little or nothing to do with their capacity to serve as jurors, but increasingly those questions were not the same questions that white citizens called for jury service were being asked. And so we were struggling as a state, as a community of criminal justice officials with how to tap into that. And of course, we had seen McCleskey, and McCleskey was rightfully viewed as one of the more shameful opinions in the Supreme Court's history. Particularly shameful was the notion that we could recognize that race had an undue impact on the operation of the system, but it was too difficult to tease out. And it really wasn't the federal judiciary's responsibility to try to tease that out. And if you tried to tease that out, the whole fabric would fall apart. That's a frustrating response to get from the Supreme Court. And looking at the court's invitation to the state legislatures to create a fix, good people in our legislature said, well, let's try to create a fix. And so in 2009, we passed the Racial Justice Act, which said that, if in fact race played an undue role in either the decision to seek the death penalty, to impose the death penalty, or in selecting jurors to preside or to sit in that in the trial, that showing could lead to the reversal of the death sentence and an imposition of a sentence of life without parole. It was a historic piece of legislation. Importantly, one of the things that, two important features. One was that statistical evidence, scientific evidence, would be admissible. And for many years, one of the frustrations where we were not able to admit statistical evidence of discrimination in our classic lawsuits, in our classic motions. Well, this was an expression by the General Assembly saying that in the criminal justice arena, just like in the public health arena, just like in industry, in every other walk of life, science would be allowed into evidence. And so there was an open invitation to include statistical and scientific evidence, and that was incredibly helpful. I think the other part that I thought was very dramatic and very important was a suggestion that we're not necessarily accusing prosecutors and judges of racial animus. We're not suggesting that what our jurors are confronted with in 2010, 2012 is Bull Connor, or folks who believe the African American jurors are no more than monkeys. It's not that level of animus. What we are talking about is a legacy in the courthouse of regarding African American jurors, citizens, as something less than full citizens, either intellectually or as a part of morality, or with respect to some prosecutors, who were more interested in just winning if it was viewed that black jurors were an obstacle to winning, securing the death sentence for whatever reasons. The prosecutor may not have racial animus, but he connects race to a particular outcome, independent of what the jurors' actual feelings are on the relevant questions. And so I thought the General Assembly was looking for discriminatory impact as opposed to discriminatory intent. And I think that was an important innovation in the law.
And when you went out and gathered the statistics and presented them to the court, what did you find?
Well, Steve, it was overwhelmingly powerful. According to the statute, we were tasked with identifying the impacts both on a statewide basis, on a countywide basis, and then on the individual case itself. And the consistency of the numbers were just mind-boggling, whichever way you looked at it. If you were African American, you were somewhere between 2.5 to 3 times more likely to be excluded from jury service than if you were white. Now, of course, that did vary with respect to counties. And so some counties, it was dramatically higher. And so in some counties, it would consistently hover closer to the 3 or exceed 3. In other counties, it would be closer to the 2. But one of the things, I'm not a statistician, that's not my training, but I've had some invaluable contact with the researchers, Catherine Grosso and Barbara O'Brien, and these differences to them are incredibly large. I mean, you're talking about 3 times the likelihood of being excluded if you're African American than if you're a white citizen. That kind of ratio is incredibly powerful.
And this was based on an analysis of all the jury strikes in capital cases all over the state of North Carolina?
Yes, what they did, and it was an enormous effort. I think it was 173 cases that received the death sentence. They polled every single juror, every single citizen that was called for jury service in those cases. In almost all of those cases, there were questionnaires, often very voluminous questionnaires. There was long transcripts. One thing about North Carolina is you have fairly broad voir dire. And so the transcripts go thousands of pages. They're often weeks long of jury.
This is the questioning of the jurors.
That's right.
During the jury selection process.
That's exactly right. And so these researchers use literally scores of law students and some certified attorneys to go out to the county courthouses to pull both the questionnaires. The clerks had their own charts where they recorded and calculated the strikes, peremptory and cause strikes for the government, for the state, and by the court. All of these original documents were secured and processed by these independent researchers and the staff of law students and investigators that they supervise. It was an enormous effort. There are thousands, I believe the actual number was somewhere between 7,000 and 8,000 citizens whose responses were evaluated under this incredibly complicated methodology. And the results were simply powerful.
And eventually those results were presented to the court in Cumberland County there in North Carolina in a couple of cases?
Indeed. It first started, first of all, I should say that we attempted to organize with the district attorneys a sort of orderly way, an orderly process of litigating the cases. We had meetings with the DA, with the AG's office to see if we could come up with sort of a complex litigation strategy. In the end, they declined. They didn't want an orderly process to it. And so, as it happens, it was sort of left to a random selection of when a particular case would be filed and who would put it on for hearing. And we ended up with the first case being litigated in Cumberland County. As it happens, the senior resident Superior Court judge of Cumberland County was a judge named Greg Weeks, who was perhaps one of the most well-respected trial judges in the state. Incredibly bright, incredibly fair, and skilled with respect to criminal practice and criminal procedures. Very well thought of in the county and in the state. And he conducted a hearing after, and you'll appreciate this, Steve, after several motions of continue by the state.
Right.
You know, he bent over backwards to afford them every procedural opportunity to get ready for the study that we had prepared. And they had claimed that they wanted to do some independent research, and he gave them time to do that, to amend their response to our study. And so there was an extensive hearing where the researchers gave, days and days and days of testimony regarding their methodology, the sourcing of the documents, and then the statistical analysis. And even for a non-lawyer at that time, I'd left the trial team, but I sort of watched from a distance as the testimony came in, and the statistical evidence was really quite overwhelming. One of the things that I thought made it powerful, both as a piece of litigation, but also as a method as a vehicle for public education, was in addition to the statistics, there was a good amount of anecdotal testimony about the practices in Cumberland County. In very significant part, you had senior members of the bar, all of them white, who offered affidavits about their exposure to the sort of discriminatory practices in the county. And even these affidavits of lawyers who were not willing to suggest that there was racial animus by the assistant district attorneys. And in fact, one of those senior district attorneys is someone that I know and know very well, and I would hesitate to accuse him of racial animus. But patterns develop, where even in the absence of animus, there was a consistent pattern of African-American jurors being excluded at these enormously high rates. And that was a piece of particularly powerful evidence.
So what you saw here is, well, you might look at one case and see 5 African-Americans struck, and it may not be that impressive. When you put all the cases together, the evidence was just too much to be, it just couldn't be a matter of chance.
That's exactly right. Over the course of 173 cases, and I forget now how many of the 100 counties in North Carolina had death sentences, you never found a county where the ratio was 1 for 1, which would be the statistical evidence of perfect equality.
That a person who's black has just as much chance of being struck, or a person who's white has just as much chance of being struck.
Right. I mean, there were those aberrations where you'd have a county to the far west or the far east where they just didn't use the death penalty very much. And so you had very little statistical basis. And so some of that cases, some of the evidence there was weaker, less powerful than in others. But even in those cases, the ratios were still suggestive of discrimination. In Cumberland County itself, one of the powerful anecdotes was the cases of Burmeister and Wright. And these were the 2 young white men who went in Cumberland County hunting for black people to kill. And they found some black people to kill, and they killed them. Interestingly, in that case, I think there were 10 African-American jurors who were passed. I believe 9 of them were passed by the state, which was incredible.
Meaning excluded from service, struck by the state.
No. They were allowed.
Oh, allowed. I'm sorry.
By the district attorney. The one case where the discrimination factor was, I think, 0.5 happened to be in the case where the white defendants were charged with racially charged killings of African American jurors. In that one case, the prosecutors decided that, oh, these African American jurors, they can be fair. You looked at the questionnaires, and those questionnaires had all of the same characteristics of African American jurors. You had contacts with the criminal justice system. You had same, historically black colleges attended, all of the same things that they would in other cases use to exclude. In that particular case, they used because they believed race meant something. And so they purposely sat, African American jurors in that racially charged case with white defendants. So it's sort of we looked at it as a flip of the racial dynamic, but it was still powerful evidence of the racial dynamic in that particular prosecuting office.
That race mattered.
Race matters. In fact, race was pivotal. Race was determinative of the voir dire jury selection strategy of the district attorney.
Now, one of the other anecdotal pieces of evidence was this cheat sheet, right, used by the prosecutor?
And Steve, I'm not quite sure how that came to light. I'm getting up in age. I just can't remember how it came. But what we learned was in 1995, the North Carolina District Attorney Association conducted one of their teaching seminars for the district attorneys from across the state. And it was actually entitled the Top Gun Seminar, meaning the elite of the district attorneys, assistant district attorneys, would come. These would be the ones who were practicing capital litigation. And in that seminar, what they did was they literally prepared a cheat sheet of excuses, pretexts for excluding African Americans. And if you remember Justice Marshall, Thurgood Marshall's opinion, I think it was a concurring opinion in Batson, where he said this three-step process isn't going to work because we can imagine that they're going, if you can so easily overcome a prima facie showing of discrimination by asking the litigant to come up with reasons, well, that's going to be an illusory protection because it'll be so easy to overcome. And in fact, with this Top Gun sheet, all you had to do is go through the 15 reasons: eye contact, body language, slow to respond,
so basically it was a list of race-neutral reasons. So when the prosecutor struck an African American and the judge said, "Why?" you just looked down at the list and picked one of the reasons.
You just pick a handful.
Right.
There'd be 15 reasons. You pick your top 4 or 5. And those that seem to me most fitting with respect to the particular case or the particular juror. And I mean, it really did shine a light on the credibility of the approach of the district attorneys, and to know that what they're being trained and how they're being schooled, not to protect the rights of good, hardworking citizens who respond to a summons for jury service, but they're actually using this as a ploy to exclude those persons from a basic responsibility and right of citizenship. So it's disappointing as a member of the profession. It's disappointing as a member of the community to know that our public officials are being trained in that way to basically trample on the basic rights of citizens.
Well, you mentioned this case went before one of the most senior and respected judges in North Carolina. How did he handle, or what was his determination of the evidence that was presented by both the prosecution and the defense in this case?
Well, as I mentioned, he gave both sides, clear room as litigators to present their case. And I should say that the case that was presented, the study that was presented by the district attorney, as it turned out, was really just a collection of surveys that had been sent out to the district attorneys. And the survey responses were basically to questions like, did you intend to discriminate against African Americans? What was your approach to jury selection? Those sorts of questions. And it would not be surprising to note that most of the district attorneys that responded said, they had no racial animus, and they were colorblind in their jury selection. So the judge went through in very workmanlike fashion the evidence that was submitted at trial, the the um, the very peer-reviewed study from the Michigan State University researchers, the independent statistician that had reviewed the study, concurred with their approach. We had an expert in race in the criminal justice system, a person very well known to you, Brian Stevenson, who talked about similar studies in other southern states where the death penalty is employed. He had an opportunity to not only review the study, but also the anecdotal evidence that was submitted. So Judge Weeks reviewed the entirety of that testimony, and not with reluctance, but it was one of the most sober opinions you're going to read from a sitting superior court. And I thought it was eloquent. I mean, it went actually back to the history of slavery and Jim Crow, and without at all calling any of the participants, the district attorney, the prosecutors, the law enforcement officers, racist, or even suggesting that they were racist, identified the problem with some legacies of discrimination that it sort of tore at his heart, because this was his home county, impacted the processes in his courthouse. And so I think while it may have been a very sober opinion, it was a powerful one because it reviewed the evidence that was presented, and the evidence was quite simply overwhelming, both statistical and anecdotal. And as litigators, when you're in receipt of that kind of overwhelming evidence, the systems that you as a lawyer support and work within, that they are systematically being used to target and deprive hardworking citizens of participation in the system, it's a hard thing to accept when it's in black and white like that. And so I think the opinion that came out, Steve, it had to be a 100-page long order. And it just sort of in workmanlike fashion, just sort of worked through the evidence. And one of the things that there was tremendous evidence on implicit racism. That what we're talking about here is not any sort of conscious decision of district attorneys to shame, criticize, demean African American citizens. But part of the legacy is that the view that African Americans, look at the government differently, look at crime differently, value crime victims differently. That's some of the baggage that we walk around with. And it was Professor Summers from, I think it was Tufts up in Boston, that presented some powerful evidence about implicit bias. And this is just the way folks organize their information. It doesn't reflect animus, but it reflects convenience. It reflects shortcuts to reaching conclusions. We all do it. And it's just that, when things become sort of received notions of truth about who's strong for law enforcement or who's anti-government, those things help people organize the way they look at the world and how they look at the citizens in the jury box. And those are the biases that the study reflected. And ultimately, that Judge Weeks said violates our Constitution, and most clearly violates the Racial Justice Act.
So really a combination of history, culture, and unconscious or implicit racial attitudes that came into play.
Right. There were the three pieces there.
Right.
The three pieces came together and fit in a way that was, I think every observer of the hearing thought was overwhelming. I have not seen as one-sided a an important legal engagement as that litigation was. One-sided not because of the amount of resources that were available to one side or the other. You went into the courtroom, there are plenty of lawyers over there. The lawyers over there had the benefit of all of the statewide resources of the Attorney General's office and everything else. It was one-sided, Steve, based on just the substantive evidence, the scientific approach to the evidence, the professional management of the evidence and of the witnesses. That was literally one of the most one-sided pieces of litigation I've seen. And what was, I think, scary to people who were opposed to the objectives of the Racial Justice Act is looking down the road, looking at the future. It was hard to see how that dynamic would change. It was hard to see, what would be the best scientific criticism of the study. How would you attack some of the anecdotal evidence that was presented? And I imagine those folks struggled mightily with that. I should say there were some strategic considerations from our side that influenced it. The Racial Justice Act talked not just about jury selection, but about the decision to seek the death penalty and the decision to impose the death penalty. Those parts were involved in a separate study by the same researchers at Michigan State University. And I, for one, not a statistician, could see in their report that the strengths of those other parts of the study wasn't as clear, wasn't as strong as the jury selection study. And so we made some strategic decisions that those parts of the study we would not deal with at this hearing. We essentially bifurcated the litigation between the jury selection part of the study and the decision to seek the death penalty on the district attorney's part. And just as a matter of science, it would have been a much more complicated hearing to show that the decision to seek the death penalty violated the statute and or the Constitution. I think if we had made a different strategic move and put the entire study in litigation, things would not have been perhaps as clear, perhaps as overwhelming as it was with the sort of bifurcated part. And I think once that decision was made, and you'll know Kenny Rose and Ty Hunter, Jim Ferguson, Jim Cooney, we're all part of that decision. That decision went a long way towards having as clear an outcome, a decision by the court, and as overwhelming an evidentiary basis supporting that decision as we could have imagined. Sometimes, Steve, you win too much.
Well, I was going to say, this is a very disturbing finding by a senior judge, a respected judge there in North Carolina. I believe there were two cases in which Judge Weeks found that race was a significant factor and therefore the death sentence had to be set aside. What was the response of North Carolina to these disturbing findings about the fact that race had played such a role in the selection of juries there in North Carolina?
Well, there was the one case, Marcus Robinson was the first case. After that, 3 cases were combined. And so there was a second piece of litigation, second set of hearings, but they combined 3 cases in that second case. The same kind of evidence, many of the same witnesses were called. The government had, obviously more of an opportunity to be prepared for the nature of the evidence. And Steve, their presentation the second time around was no stronger, no more effective than the first. And in fact, as a criminal defense lawyer, you rarely look forward to retrials because you think the other side is more prepared. You've shot your gun, you've exposed your evidence. Surely they'll have all of these powerful comebacks. Well, Steve, that wasn't the case here. This is one of those situations where just the merits of the evidence, both statistical and anecdotal, it didn't matter if they had another 6 months to go after it. a doubling of their budget to go after it, they were not going to change the essential facts of the litigation. And they didn't. If anything, because of the three cases, we had more anecdotes to pick from to sort of add to the spice of things at that hearing than at the earlier hearing. The result was exactly the same. But I believe it was in between those two hearings, Steve, if I'm not sure I've got the dates precisely in mind, but I think it was shortly after the Marcus Robinson hearing, but before the Golphin hearings, that the repeal of the Racial Justice Act happened. And there were negotiations. First of all, there was the amendment of the Racial Justice Act, which, was sort of a compromise reached by the partisans at the General Assembly, where they made two essential provisions. One is that statistical evidence by itself could not result in the overturning of a death sentence. And basically what that meant is you'd have to provide anecdotes, descriptions of discriminatory behavior by the local district attorney or the court system. And the second provision was that you'd have to show evidence within the case itself, the defendant's case itself, that he was subjected to actions that were discriminatory. And I believe that happened, the amendment happened before the second set of litigation. Didn't change the outcome, both because the litigators were prepared with the anecdotal evidence, the non-statistical evidence to supplement the work by the researchers from Michigan State University, and that included evidence of race-specific, discriminatory-specific stuff in the case itself. One of the things, Steve, that has been powerful in the litigation and the preparation of these cases is once you get past the statistical evidence, and for some of us, statistical evidence is not boring, but you can only talk about that for so long, right? I mean, the results are, 56% of African Americans are excluded, 24% are white. They'll vary from county to county, they'll vary over time, but that's basically the band of that evidence. What's so disturbing are these affidavits from individual citizens, affidavits from jurors who misrepresented things in their questionnaire about their own histories with violence or with race. And these things came up, the Rouse opinion, where one white juror simply didn't tell folks that his mother had been murdered by an African American, and he thought that all black men were violent. And he didn't feel the need to share that in jury selection. Well, that's not part of the study, that's not part of the research piece, but does it inform the quality of justice in that county? Those post-conviction motions, which revealed that bias, were made shortly after the trial. It didn't affect the post-conviction court. Didn't provide any relief. So we're now, through the guise of the Racial Justice Act, looking at a conviction and a death sentence that ignored the fact that a juror literally misrepresented, if not lied, under oath, under questioning, and kept from the litigators evidence that was critical to his fairness to sit in the trial. And our court system said that didn't matter. So it's this sort of constant refrain that the value and the quality of African American citizens, it just doesn't measure up to the value and the appreciation given to citizens who are white, who are responding to their call to duty. And it was just a constant drumbeat of evidence after evidence after evidence that that's the case in counties throughout the state. One of the tragedies I see, we're not quite sure what the effect of the repeal of the Racial Justice Act will be. It's all...
Actually, the legislature, after that amendment that you talked about, after the second hearing, they actually repealed the act. Is that correct?
That's correct. And we're still litigating what the impact of that repeal is. But after the elections of 2010, then elections of 2012, the partisans' opponents had control of the state house, state senate, and the governor's seat, and they simply ran the table on the Racial Justice Act and just took it off the books. And Steve, you'll note that it was the same running of the table that resulted in the most outrageous, most notorious voter suppression legislation in the country. You can't really keep them separate. It's part of the same initiative. But with respect to the Racial Justice Act, it took the Racial Justice Act off the books. Now, for the 158 people who have filed petitions, and those petitions are in one state of litigation or another, it's not clear whether that repeal, how that repeal will affect their rights. We're continuing to litigate those cases. But one of the things that's absolutely painful to me is that the public education that goes on in the litigation of these cases in the small county courthouses of our state get enormous publicity in that county. And it's such a missed opportunity for public education, for our young voters, our middle-aged voters to see what happens in the courthouse. Right. People are not often attuned to the country and the state's civil rights history. They're even less attuned often to what happens in their county courthouse. And the Racial Justice Act litigation was an opportunity to bring all of that fairly remarkable history, local history, before the eyes of local citizens at the county level, at the municipal level. And I think there's just very few public education vehicles as powerful as the litigation of the Racial Justice Act. And I think it's a tragedy to shut that door, to prevent our citizens from having that educational experience.
And of course, in other states, that educational experience is not taking place because there is no Racial Justice Act. And it's certainly sobering that the North Carolina legislature, upon finding, have judicial findings of race entering into the influencing these capital cases, instead of dealing with the fact that race is entering into them, repeal the Racial Justice Act so that no longer would those issues be discussed, would that public education take place, and would the state grapple with the issue of race and the death penalty. Basically, that's off the table now, right?
Yeah, it's a shameful occurrence, and it's hard to know because the thing has become such a partisan issue. Right. How people of goodwill, people of good faith, can endorse a strategy which shuts the door on that kind of public education without thinking or suggesting that they harbor some inappropriate biases. And does it help to suggest that it's part of a partisan agenda so that people can join in that agenda without sharing the animus or the bias? It's like counting the angels on the head of a pin. It's an exercise I find futile, but it's painful. The result is something that's painful. I'm not sure how we reverse that kind of decision. So as a matter of state public policy, as a matter of educational potential in the state, I don't know how we get back the opportunity to present a witness like Brian Stevenson and to have his testimony covered locally by radio stations, local newspapers, and to have someone of that quality review the evidence that's been presented and link that to the history and legacy of racism and race discrimination in our justice system in the South. It's an opportunity that you're not going to often get in Cumberland County. It's not an opportunity you're often going to get in Union County, North Carolina, in Duplin County, North Carolina. And that's what the Racial Justice Act afforded the citizens of North Carolina, and we've lost that now.
Well, Henderson Hill, thank you very much for describing this time and what the state of North Carolina did and what they found, and it's immensely helpful for us in understanding these things. Thank you very much.
Thank you, Steve. Good luck.